As a continuation to the discussion of special types of workers, we will go to student workers. The employment of student workers is governed by RA 7323 as amended by RA 9547 and further amended by RA 10917. So under this amended law, any person or entity employing at least 10 persons. So those who are employing less than 10 persons may not or are not allowed to hire student workers. So if you are an entity or person employing at least 10 workers, you may employ poor but deserving students, out of school youth, or dependents of displaced or would-be displaced workers due to business closures or work stoppage or natural calamities. And these students are intending to enroll in any secondary, tertiary, or technical vocational institutions. Third, they must be 15 years of age, but not more than 30 years old. Then the employer will be paying them a salary or wage not lower than the minimum wage for the private employers and the applicable hiring rate for national and local government agencies, because student workers can be hired in private and in national or local government agencies. Another requirement is that students enrolled in secondary level shall only be employed during summer and or Christmas vacations, while out of school youth and those enrolled in tertiary, vocational or technical education may be employed at any time of the year. Another one, that their period of employment shall be from 20 to 78 working days only, except that during Christmas vacation, employment shall be from 10 to 15 days, which may be counted as part of students' probationary period should they apply in the same company or agency after graduation. And finally, the students employed in activities related to their course may earn educational or earn equivalent academic and practicum or on-the-job training credits as may be determined by the appropriate government agencies. Provided that the parents of these student workers, the combined income does not exceed the annual regional poverty threshold for a family of 6 for the preceding year as may be determined by the National Economic and Development Authority. The employment facilitation services for applicants of the program shall be done by the Public Employment Service Office. Now, how should the wage of these student workers be given? 60% of the salary or wage shall be paid by the employer in cash, and 40% shall be paid by the government in form of cash directly to the student or through financial institution or other payment facility. subject to existing rules on procurement, which shall be applicable in the payment for students' tuition fees, books, and other school education-related expenses, including their daily allowance for food and transportation in going to school. The local government unit may assume responsibility for paying in full the salary or wages, provided that for low-income LGUs employing SPES beneficiary, the national government share may be increased up to 75% depending on the LGU's financial capacity to pay the SPES beneficiary. SPES means Special Program for Employment of Students, and it refers to Doli's Youth Employment Bridging Program, which aims to provide temporary employment to poor but deserving students, out-of-school youth, and dependents of displaced or would-be displaced workers during summer and or Christmas vacation or any time of the year to augment the family income, to help ensure the beneficiaries are able to pursue their education. So that's how the money will be paid to the workers, student workers. We will distinguish student worker from working scholars. In working scholar, there is the employment of working scholar, there is no employer-employee relationship. This is an arrangement where students are hired to perform jobs or activities in the school premises under a written agreement in which the former agrees to work for the latter in exchange for the privilege to study free of charge, provided that students are given real opportunities, including such facilities as may be necessary or unreasonable to finish their chosen courses under such agreement. So it is different. In this case, working scholars do not receive wage or wages under Section 14, Rule 10, Book 3 of the Implementing Rules. So since there is no employer-employee relationship, if the working scholar causes damage to another person, there will be no liability on the part of the school. In the case of Philomer Christian Institute versus Honorable Court of Appeals, October 16, 1990, the student here is liable for negligence, causing damage to third person. In this case, the working scholar without permit drove the vehicle owned by the school and caused damage to another person. There is also another type of students, especially those under the on-the-job trainees. Definitely it's a special type of arrangement where there is no employer-employee relationship, where the students here are accepted by the company for exposure purposes in relation to the courses that they are enrolled. There is only maximum number of hours where they are assisted by their supervisor from the school who will oversee as to their participation in the conduct of work. So there is no compensation due to the students who are under on-the-job training, and no employer-employee relationship. Another group of special type of workers would be the domestic or household service workers. We are talking of RA 7655 as amended by RA 10361, the Kasambahay law. First, let's look at the rights of a domestic worker. The right of a domestic worker to fair treatment. Under 1036 RA 10361, the employer shall provide for the basic necessities of the domestic worker to include at least 3 adequate meals a day and a humane sleeping arrangement that ensures safety. The employer shall provide also appropriate rest and assistance to the domestic worker in case of illness or illnesses and injuries sustained during service without loss of benefit. At no instance, the employer shall not withdraw or hold in abeyance the provision of these basic necessities as punishment or disciplinary action to the domestic worker. What about the right of the domestic worker to education? Under the Civil Code, what is required is elementary education. Under the new law, Section 9 RA 10361, the employer shall afford the domestic worker the opportunity to finish basic education and may allow access to alternative learning systems and, as far as practicable, higher education or technical and vocational training. So the law now requires to provide the domestic worker basic education and access to alternative learning and, as far as practicable, higher educational, technical and vocational training. The Civil Code requires that the contract shall not exceed 2 years and can be renewed from year to year. And in this contract, the language or dialect must be understood both by domestic worker and the employer. Although this is not commonly followed in actual practice, but the Civil Code requires that there must be a contract. Another privilege or benefit of a household worker is the right against abuse and violence. Under Section 5 of RA 10361, the employer or any member of the household shall not subject the domestic worker or kasambahay to any kind of house or abuse, nor inflict any form of physical violence or harassment or any act tending to degrade the dignity of the domestic worker. As regards hours of work, under the new law, as compared to Article 1695 of the Labor Code, which provides that the house helper shall not be required to work more than 10 hours a day, or shall be allowed 4 days vacation each month with pay. The new law under Section 20 provides the domestic worker shall be entitled to an aggregate or total daily rest period of 8 hours per day, which means that when you say 8 hours, then there are 24 hours in a day, so the employee can be working for 16 hours, longer than the 10 hours mentioned in the Civil Code. The rest period of a domestic worker is more or less the same with a private or workers employed outside domestic or household service. The worker here is entitled to 24 consecutive hours of rest in a week. The employer and the domestic worker shall agree in writing on the schedule of a weekly rest day of the domestic worker. So there must be an agreement in writing, and provided that the employer shall respect the preference of the domestic worker as to the weekly rest day when such preference is based on religious grounds. Nothing in this provision shall deprive the domestic worker and the employer from agreeing the following. 1. Of setting a day of absence with a particular rest day, waiving a particular rest day in return for an equivalent daily rate of pay, accumulating rest days not exceeding 5 days, or other similar agreements. In case the domestic worker dies, then the head of the family shall bear the funeral expenses if the house helper has no relatives in the place where the head of the family lives with sufficient means, therefore. When it comes to termination of service, under Section 32 of the new law, neither the domestic worker nor the employer may terminate the contract before the expiration of the term, except for grounds provided for in Section 33 and 34 of this law. If the domestic worker is unjustly dismissed, the domestic worker shall be paid compensation already earned plus equivalent 15 days work by way of indemnity. If the domestic worker leaves without justifiable reason, any unpaid salary due not exceeding the equivalent 15 days shall be forfeited. In addition, the employer may recover from the domestic worker costs incurred related to the deployment expenses, if any, provided that the services have been terminated within 6 months from domestic workers' employment. The law also requires at least 5 days notice before the date of termination of service. On the other hand, the domestic worker under Article 33 may terminate employment relationship at any time before the expiration of the contract for any of the following causes: verbal or emotional abuse by the domestic worker by the employer or any member of the household, inhuman treatment including physical abuse of the domestic worker or by the employer or any member of the household, commission of a crime or offense against domestic worker by the employer or any member of household, violation by the employer of the terms and conditions of employment contract and other standards set forth under this law, any disease prejudicial to the health of the domestic worker the employer, or any member of household, or other analogous to the foregoing. On the other hand, on the side of the employer may also terminate the services of the domestic worker prior to the expiration of the contract for any of the following grounds, as enumerated in the just causes under the Labor Code. In addition to the just causes, you also have violation with the domestic worker of the terms and conditions of employment contract and other standards set forth under the law, or the worker suffers disease prejudicial to his health, or to the employer or member of the household, or any of the analogous to the foregoing. Then, if there is termination of employment, there must be certification issued by the employer to the employee. When it comes to minimum wage, in Metro Manila, the kasambahay starting January 2021, the monthly salary of kasambahay shall be 5,000. I mean January 2, 2020. It will now be 5,000 per month. In all other outside Metro Manila, the provision of the old law still applies. For those who are employed in chartered cities or first-class municipalities, 2,000 per month, and 1,500 pesos a month for those employed in other municipalities. The payment of wages shall be made directly to the domestic worker to whom they are due in cash at least once a month. The employer, unless allowed by the domestic worker through a written consent, shall make no deduction on the wages other than which is mandated by law. No employer shall pay the wages of domestic workers by means of promissory notes, vouchers, coupons, tokens, tickets, cheats, or any other object other than cash wage as provided for in this Act. The worker is also entitled to 13-month pay as provided for by law. There is the prohibition under Article 143 that the house helper shall not be assigned to work in a commercial, industrial, or agricultural enterprise at a wage or salary rate lower than that provided for agricultural or non-agricultural workers as prescribed therein. This was adopted under Article Section 22 of the new law, where it provides that no worker shall be assigned to work in a commercial, industrial, or agricultural enterprise at a wage rate lower than that is provided for agricultural and non-agricultural workers. In such cases, the domestic worker shall be paid the applicable minimum wage. Under DO number 4, series of 1999, domestic workers between 15 to 18 years old may be allowed to engage in domestic or household services as long as the work is not deleterious or hazardous. Other salient provisions of the Kasambahay Law are RA 10361. They have the guarantee of the right of privacy of the domestic worker. They have access to outside communication. And then prohibition against privileged information. This rule provides that all communication and information pertaining to the employer or members of the household shall be treated as privileged and confidential, and shall not be publicly disclosed to the domestic worker during and after employment. Such privileged information shall be inadmissible in evidence except when the suit involves the employer or any member of the household in a crime against persons, property, personal liberty, security, and chastity. So in order to qualify as privileged information, therefore, the following elements must be present: that there is employer-employee relation between the domestic worker and the employer. The information was obtained during the course of the employment, and the communication and information pertains to the employer or business of the household or members of the household. As a general rule, the privileged information shall be inadmissible as evidence in court, except in cases involving the employer or any member of the household in a crime against person, property, personal liberty, and security, and chastity. So as law students, you know what is crimes against persons, property, personal liberty, and security, and chastity. So if you present your house helper to testify in an annulment case against the husband or the wife, as the case may be, the opposing party can object, being privileged information. Another important provision is this: it shall be unlawful for the employer or any other person to require a domestic worker to make deposits, from which deduction shall be made for the reimbursement of loss or damage to tools, materials, furniture, and equipment in the household. That's Section 14. Under Section 15, it is declared unlawful for the employer or any person acting in behalf of the employer to place the domestic worker under debt bondage. So you cannot place the employee under or domestic worker in total debt bondage, so the employer cannot resign. Then the introduction or innovation of the new law is that there is the obligation of the employer to register all domestic workers under their employment in the registry of domestic workers in the barangay where the employer's residence is located. Then there is also remember the freedom of disposal rule also applies to the wages or salary or the wages of domestic workers under Section 27, where it is declared unlawful for the employer to interfere with the freedom of any domestic worker to dispose of the latter's wages. The employer shall not force, compel, or oblige the domestic worker to purchase merchandise, commodities, and other properties from the employer or from any other person, or otherwise make use of any store or services of such employer or any other person. Then let's look at the service incentive leave other than 13-month pay. Section 29 of 10361 provides that the domestic worker who has rendered at least 1 year of service shall be entitled to an annual service incentive leave of 5 days with pay. However, this is different compared to workers hired outside the domestic or household service, because any unused portion of the said annual leave shall not be cumulative or carried over to the succeeding years. And unused leave shall not be convertible to cash. If you'll be asked again what are the other entitlements other than service-sensitive leave and 13-month pay, under Section 30, the domestic worker who has rendered at least 1 month of service shall be covered by Social Security, the SSS, the PhilHealth, and Pag-ibig Fund benefits. Premium payments or contribution shall be shouldered by the employer. However, if the domestic worker is receiving a wage of 5,000 and above per month, the domestic worker shall pay the proportionate share in the premium payments or contribution provided for by law. If the domestic worker was recruited and hired through the private employment agencies or through this domestic recruitment, this private employment agency shall be jointly and severally liable with the employer for all wages, wage-related benefits, and other benefits due to a domestic worker. That's under Section 36. Finally, araw ng kasambahay under Section 39 has been officially declared under Section 39, which provides that the date upon signing of the bill into law will be considered araw ng mga kasambahay. It was on June 18, 2013 that President Aquino signed the bill into law. So January 18, 2013 is the araw ng kasambahay, ng mga kasambahay. Let's go to the hiring of aliens. Any alien seeking admission to the Philippines for employment purposes and any domestic or foreign employer who desires to engage an alien for employment in the Philippines shall obtain an alien employment permit from the Department of Labor under Article 40 of the Labor Code. The employment permit may be issued to a non-resident alien or to the applicant employer after the determination of non-availability of person in the Philippines who is competent, able, and willing at the time of application to perform the services for which the alien is desired. So it is prohibited that after transfer of employment, after issuance of an employment permit, the alien shall not transfer to another job or change his employer without prior approval of the Secretary of Labor. And any non-resident alien who shall take up employment in violation of the provision of this title and its implementing rules and regulations shall be punished in accordance with provisions of Articles 289 and 290 of the Labor Code. In addition, the alien worker shall be subject to deportation after service of sentence. The duration of the alien employment permit shall be for a minimum period of 1 year starting from the date of its issuance unless sooner revoked by the Secretary of Employment for violation of the Code of Rules. There is the requirement of the understudy training program. The employer shall submit a training program for his understudies to the Bureau within 30 days upon arrival of the alien. The supervision of the training program shall be the responsibility of the Bureau and shall be in accordance with the standards established by Secretary of Labor. Under Department Order Number 186, Series of 2017, the following are exempted from securing the alien permit. All members of diplomatic service and foreign government officials accredited by and with reciprocity arrangement with the Philippine government. Officers and staff of international organization, which the Philippines is a member, and their legitimate spouses desiring to work in the Philippines. Owners and representatives of foreign principals whose companies are accredited by POA who come to the Philippines for a limited period and solely for the purpose of interviewing Filipino applicants for employment abroad. Another, foreign nationals who come to Philippines to teach, present and/or conduct research studies in universities and colleges as visiting, exchange, or adjunct professors under formal agreements between universities or colleges in the Philippines and foreign universities or colleges, or between Philippine government and foreign government, provided that the exemption is on a reciprocal basis. Permanent resident foreign nationals and probationary or temporary resident visa holders under Section 13A to F of the Philippine Immigration Act and Section 3 of Alien Social Integration Act of 1995. Another, refugees and stateless persons recognized by DOJ pursuant to Article 17 of the UN Convention and Protocol relating to status of refugees and stateless persons. And finally, all foreign nationals granted exemption by law. Section 3 of the said order also provides further exception from employment permit. The members of the governing board with voting rights only and do not intervene in the management of the corporation in the day-to-day operation of the enterprise. The president or treasurer who are part owner of the company, or those providing consultancy services who do not have employers in the Philippines. They also have intra-corporate transferee who is a manager, executive, or specialist as defined by law in accordance with trade agreements, and employees of foreign service suppliers for at least 1 year prior to deployment to branch, subsidiary, affiliate, or representative of the Philippines. Then you also have contractual service supplier who is a manager, executive, specialist, and an employee of a foreign service supplier which has no commercial presence in the Philippines. And lastly, representatives of foreign principal employers assigned in the Office of Licensed Manning Agency in accordance with POA law, rules, and regulations.